Gay American couples are using surrogates abroad to have children, and they're finding that their babies are not automatically U.S. citizens. The U.S. State Department does not recognize the citizenship of one U.S. couple's baby. That's because the sperm used to conceive the child was from her British-born father. Because neither the father nor the surrogate were born in the U.S., despite the fact that the father is a U.S. citizen, I hope you're following me, the child does not qualify for citizenship. So joining me now is the New York Times reporter who covered this story, Sarah Mervosh. So Sarah, first off, I tried to say it slowly so people could sort of understand. It's a very interesting story. Can you just explain a little more about how this couple is getting jammed up by, a decades-old law?
Yes, it's a very complicated story, but here's sort of what it boils down to. This is a story about a policy, a State Department policy for children born abroad through assisted reproductive technology. And at issue is that the State Department policy requires a biological connection to an American parent in order to transmit citizenship. And it also treats assisted reproductive technology cases as out of wedlock if there's not a match between, say, the egg and the sperm and two married parents. And so what you have is a situation where you could have American families where one parent or even both parents, like in this case, are American citizens, but the child is not.
So I called it a law. You said it's a policy, not a law. Okay, so that's
interesting.
Go ahead.
It's a State Department policy based on an interpretation of immigration law that dates back to the 1950s. So there's language in immigration law, that states children are born of their parents and mentions a blood relationship in certain cases. And so the State Department for many years now has interpreted that to mean that there needs to be a biological connection to an American parent to transmit citizenship.
So though this is a same-sex couple, the same would have applied for decades to a couple with two different sexes.
Correct. And so that is something that the State Department has argued in court, that it does apply to opposite-sex couples as well. But there are some issues where, a same-sex couple would not be able to provide the same, two biological connections to a married parent in order to transmit citizenship in the same way that, if an opposite-sex couple was able to provide, the egg and the sperm, they might be able to provide two touches and then be considered in wedlock.
So what are some of the ethical debates being had around this challenge, and are there lawsuits against these decisions?
Yeah, so again, like I just mentioned, it is a policy that's been around for quite some time now, but right now there are two pending lawsuits against the State Department that allege discrimination against same-sex couples. The lawsuits allege that the State Department policy does not recognize same-sex couples' legally recognized right to marry that they've had for the past several years now. And so that's pending through court, and this is just bringing up a lot of debates right now. Again, we've got decades-old law and modern families, same-sex couples who are, marrying and having families, as well as all couples who are increasingly using assisted reproductive technology to have children. And again, this applies to children born abroad through assisted reproductive technology. And if you're born in the United States on U.S. soil, then you are automatically considered a citizen.
So what about this family? Because it just seems like, they could have used sperm donated from the other partner that is American, and then they probably wouldn't be in this situation, right?
Right, and so one issue is that this policy was just not super well known among all families, and so families are finding themselves in this situation. And also they argue that they shouldn't have to sort of decide between the two. But yes, if the sperm had been used from the father who was born and raised in the United States, this wouldn't be an issue, because the issue with the other father is that he is an American citizen, but because of certain requirements with this policy, an out-of-wedlock birth, again, they are married, but it's out of wedlock because of the assisted reproductive technology, requires some extra requirements. And so there's a residency requirement, and this father, who was born in Britain and lived in Britain for many years, did not qualify. But they're now living in Atlanta, and they're basically trying to assess their options, as far as I can tell. And they're struggling with some difficult decisions, and as of right now, they're planning to go back and forth until they can get it figured out.
Wow. Very interesting story. It's time, clearly, that the policies sort of catch up to modern technology and modern times. Sarah Mervosh, thank you so much.
Thank you.